right? If the vote cast or the majority of votes accruable or scored by a particular candidate or party is not lawful. So it is not enough for one to have majority of votes. One must have majority of lawful votes cast. Now, where a party or candidate who participated in the said election is aggrieved and decides to activate the machinery of justice, the instrumentality of the law to challenge the outcome of the electoral process through the petition, one can bring that petition on several grounds, which I'm going to highlight. But let us note, by way of further introductory remarks, that only two entities in law, or two persons as it were, can file a petition, either conjunctively or disjunctively. I will explain that shortly. Who are these two entities or persons? One is a political party. The second is the candidate, a candidate. In other words, the local standard, that is the standing, the legal right to activate the law to challenge the outcome of an election by way of petition, can only accrue to a petitioner if that petitioner is deemed, seen, and known to be either a candidate that participated in that election or a political party. So, in simple terms, we have 18 registered political parties in Nigeria on record. It is only the political parties that participated. By participation, I mean that had candidates, that filed candidates, that can go to the tribunal to challenge the outcome of an election. It is also only a candidate that can do so. Recall I had just a while ago said that this can be done either conjunctively or disjunctively. Conjunctively in the sense that both the candidate and the party may file a joint petition, in which case you will have a first petitioner and a second petitioner. Or disjunctively, in which case the party can decide to go to court without the candidate. The candidate can also decide to go to court independent of the party. So that right that accrues to the party and the candidate is exercisable, as I said, I want to reiterate, either conjunctively or disjunctively. Now, under the current Electoral Act, if you look at the provisions of the Act, Section 134 and the rest, the Electoral Act 2022 has essentially articulated the grounds, the legal grounds, under which or upon which a petition can be brought. So the fact that one has grievances arising from the conduct of a particular election does not automatically vest, clothe, or empower the person. By person here, I mean a party or candidate, to file a petition. The petition has to be circumscribed to the grounds that are provided for under the Electoral Act, grounds that are cognizable under the Electoral Act. And under our current Electoral Act, there are three broad grounds under which a petition can be brought. One, the petitioner can file the petition on the ground that the person returned elected or declared and returned elected did not score majority of lawful votes cast, right? Two, that the election is invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act. Three, that the person returned elected as at the time of the election was not qualified to participate in the election. There used to be a fourth ground, which was exclusion, meaning that under the 2010 Electoral Act that amended at that time, before it was repealed by the Electoral Act 2022, where a candidate was validly nominated to participate in the election, and that candidate and his party is excluded from the election, that party had the right to approach the tribunal to challenge the outcome of that election. But somehow, mysteriously, under the extant Electoral Act 2022, we saw that that provision was expunged by the National Assembly, which for me is going to lead to a lot of disputes within the legal community, because I feel that once a party has complied with the prerequisites for nomination, that party has the right to file a candidate. This is not just a question of the Electoral Act. It is a serious constitutional question. which I believe the Supreme Court will have to pronounce upon. In fact, I have a petitioner, some people that are talking to me in one of the states in the House of Assembly election, where their party's logo was not properly represented in the ballot paper. So let's assume that the logo of as it's been insinuated in some